Okay, I'm going live again. I ain't about to be talking out loud and shit, man. I'm laid way back. It's Fresh Fetty, man. The nigga King Junie. Fresh out West America Best. Howville Fetty. J Dog the Hog. Juke Joint Junie. Mr. Johnson. Murder Gang. And I got a new name. It's called, I just found out that my name ain't even my name. I got a new name. So, I really got two new names, I guess. Cause like Michi. Okay, so it's already a minute and passed, but right now today I'm about to read a little bit about some matters of law. Some good news that you need to hear, that you might need to hear. You know, you probably ain't never heard this before. If you have, it's cool. If not, then shit, you know, flap your ears real wide open. I'm reading from this book called The UCC Connection by who the fuck is it? By Howard Freeman. Okay. No, I ain't gonna put it right there. Hopefully I can hear me. Hopefully if anybody hear this shit, I'll click on this shit then. Hopefully you can hear me. I ain't never read this before. But my main man passed me this book, told me I need to check it out. So we'll start like this. The article has really found in the voids that kept me fully understanding things. I have found it to be one of the best discussions on the subject of freedom and how our own government has managed to take that freedom away from us, all the while giving lip service to the Constitution. The title of this article is The UCC Connection. The noteworthy article is Howard Freeman. It is dated September 22nd, 1991. The UCC Connection, How to Free Yourself from Legal Tyranny by Howard Freeman. Forward. This is a slightly condensed, casually paraphrased transcript of tapes of a seminar given by Howard Freeman in 1990. It was prepared to make available Mr. Freeman's knowledge and experience in his research for an accessible and understandable explanation of the confusing state of the government and the courts. It should be helpful to those who want to develop a deeper understanding of this information without having to listen to 3 or 4 hours of recorded material. Okay. The frustrations many Americans feel about our judicial system can be overwhelming and often frightening, and like most fear, it is based on the lack of understanding or knowledge. Those of us who have chosen a path of bondage and into liberty are faced eventually with the seemingly tyrannical power of some governmental agency and the mystifying and awesome power of the courts. That didn't sound right. Hold on, I gotta read that again. Those of us who have chosen a path out of bondage and into liberty are faced eventually with the seemingly tyrannical power of some governmental agency and the mystifying and awesome power of the courts. Oh, okay. We have been taught that we must get a good lawyer but that has become increasingly difficult, if not impossible. If we are defending ourselves from the government, we find that lawyers quickly take our money and then tell us as the ship is sinking, I can't help you with that. I'm an officer of the court. Ultimately, the way for us to ever have a snowball's chance is to understand the rules of the game and to come to an understanding of the nature of the law. The lawyers have established a virtual monopoly over this area of human knowledge by implying that the subject is just too difficult for the average person to understand, and by creating a separate vocabulary out of English words of otherwise common usage. While it may be, while it may at sometimes seem hopelessly complicated, it is not that difficult to grasp. Are lawyers really as smart as they would have us believe? Besides, anyone who has been through a legal battle get this shit out of here. Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers know procedure, not law. Then answered one of the lawyers and said unto him, Master, thus saying, thou reproachest us also. And he said, woe unto you, ye lawyers, for ye lay men with burdens grievous to be borne, and ye yourselves touch not the burdens with one of your fingers. Woe unto you, lawyers, for ye have taken away the key of knowledge. Ye enter not in yourselves, and them that were entering in ye hinder. Christ teaches his disciples at Luke 11, chapter 11, verse 43 through 52. Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers learn about procedure, not law. Mr. Freeman admits that he is not a lawyer, and as such, he has a way of explaining law to us that puts it well within our reach. Consider also that the framers of the Constitution wrote in language simple enough that the people could understand specifically so that it would not have to be interpreted. So again, we find as in many other areas of life, the buck stops here. It is we who must take the responsibility for finding and putting to good use the truth. It is we who must claim and defend our God-given rights and our freedom from those who would take them from us. It is we who must protect ourselves, our families, and our posterity from the inevitable intrusion into our lives by those who live parasitically off the labor, skill, and talents of others. To these ends, Mr. Freeman offers a simple, hopeful explanation of our plight and a peaceful method of dealing with it. Please take note that this lecture represents one chapter of the book of his understanding, which he is always refining, expanding, improving. It is, as all bits of wisdom are, a point of departure from which to begin our journey into understanding so that we all might be able to pass on to others greater knowledge and hope, and to God the gift of lives lived in peace, freedom, and praise. I send you forth as sheep in the midst of wolves. Be therefore wise as serpents and harmless as doves. Matthew chapter 10, verse 16. Introduction. Hold on. Hold them up. Hey, y'all niggas need to be going to sleep, man. Okay. Hey, man, I got about 5 minutes. I'm gonna wake y'all mama up. When I beat the introduction. When I beat the IRS, I used Supreme Court decisions. If I had tried to use these in court, I would have been convicted. I was involved with the Patriot Group and I studied Supreme Court cases. I concluded that the Supreme Court had declared that I was not a person required to file an income tax, that tax was an excise tax on privileges granted by government. You hear that shit? So I quit filing and paying income taxes, and it was not long before they came down on me with a heavy hand. They issued a notice of deficiency, which had such a fantastic sum on it that the biggest temptation was to go in with their letter and say, "Where in the world did you ever get that figure?" They claimed I owed them some 60,000. But even if I had been paying taxes, I never in the world had that much money. So how could I have owed them that much? Section 1. Never argue the amount of deficiency. Fortunately, I have been given just a little bit of information. Never argue the facts in a case. Maxim. Arguments are for fools. If you're not required to file, what do you care whether they say you owe $60 or $60,000? If you are not required to file, the amount doesn't matter. Don't argue the amount. That is an issue of fact. In most instances, when you get a notice of deficiency, it is usually for some fantastic amount. The minute you say, "I don't owe that much," you have voluntarily agreed that you owe them something, and you have just given them jurisdiction. Just don't be shocked at the amount on a notice of deficiency, even if it's $10 million. If the law says that you are not required to file or pay tax, the amount doesn't matter. By arguing the amount, they would just say that you must go to tax court and decide what the amount is to be. By the time you get to tax court, the law issues are all decided. You are only there to decide how much you owe. They will not listen to arguments of law. What's so funny, nigga? So I went to see the agent and told him I wasn't required to file. He said, "You are required to file, Mr. Freeman." But I had all these Supreme Court cases and I started reading them to him. He said, "I don't know anything about law, Mr. Freeman, but the code says that you are required to file and you're going to pay that amount or you're going to go to tax court." I thought that someone there ought to know something about law, so I asked to talk to his superior. Sorry. You alright? Y'all niggas better go to bed. You know you gotta get up in the morning. I went to him and got out my Supreme Court cases, and he wouldn't listen to them. I don't know anything about the law, Mr. Freeman. Finally, I got to the problems resolution officer, and he said the same thing. He said that the only person above him was the district director. So I went to him. By the time I got to his office, they had phoned ahead, and his security said he was out. But I heard someone in his office, and I knew he was there. I went down the elevator around the corner to the federal building and into Senator Simpson's office. There was a girl sitting there at a desk, and she asked me if she could help me. I told her my problem. I said that I really think the district director is up there. I asked her to call the IRS and tell them that it was Senator Simpson's office calling, and to ask if the district director is in. I said, if you get him on the phone, tell him that you are from Senator from the senator's office. You have a person whom you are sending over to speak to him. If he is, can he wait just 5 minutes? It worked. He was there, so I ran back up to his office. The secretary met me when I came in and said, Mr. Freeman, you're so lucky. The director just arrived. The director was very nice and offered me coffee and cookies, and we sat and talked. So he asked me what I wanted to talk to him about. If you've never, if you've never have someone say to, had someone say to you, I'm from the government and I'm here to help you. If I'm from the hold on. If you've never have someone say to you, I'm from the government and I'm here to help you, watch out. But we can turn that around and approach them in that same way. So I said, I thought you ought to know that there are agents working for you who are writing letters over your name that you wouldn't agree with. Do you read all the mail that goes out of this office over your signature? The director said, oh, I couldn't read everything. It goes out here by the bagful. That was what I thought. I said, there are some of your agents writing letters which contradict the decisions of the Supreme Court of the United States. And they're not doing it over their name, they're doing it over your name. He was very interested to hear about it, and asked if I had any examples. I just happened to have some with me. So I got them out and presented them to him. The Supreme Court cases supporting Freeman's position. The director thought it was very interesting and asked if I could leave this information with him, which I did. He said he would look it over and contact me within 3 days. 3 days later, he called me up and said, I'm sure, Mr. Freeman, that you will be glad to know that your notice of deficiency has been withdrawn. We've determined that you're not a person required to file. Your file is closed and you will hear no more from us. I haven't heard another word from them since. That was in 1980, and I haven't filed since 1969. Section 2, the Supreme Court on trial. I thought sure I had the answer, but when a friend got charged with willful failure to file an income tax, he asked me to help him. I told him that they would have to prove that he willfully failed to file, and I suggested that he should put me on the witness stand. He should ask me if I spoke to at a certain time. He should ask me if I spoke at a certain time and place in Scottsbluff, and did I see him in the audience. He should then ask me what I spoke about that day. When I got on the stand, I brought out all of the Supreme Court cases I had used with the district director. I thought I would be lucky to get a sentence or two out before the judge cut me off, but I was reading whole paragraphs and the judge didn't stop me. I read one and then another and so on. And finally, when I had read just about as much as I thought I should, the judge called a recess of the court. I told Bob I thought we had it made. There was just no way they could rule against him after all that testimony. So we relaxed. The prosecution presented his case, and Bob, decided to rest his case on my testimony, which showed that he was not required to file and that the Supreme Court had upheld this position. The prosecutor then presented his closing statement saying we were just sure that we had won, but at the very end, the judge spoke to the jury and told them, "You will decide the facts of this case, and I will give you the law." The law required this man to file an income tax form. You decide whether or not he filed it. What a shock. The jury convicted him. Later, some of the members of the jury said, "What could we do?" The man had admitted that he had not filed the form, so we had to convict him. As soon as the trial was over, I went around to the judge's office, and he was just coming in through the back door. I said, "Judge, by what authority do you overturn the standing decisions of the United States Supreme Court? You sat on the bench while I read that case law. Now, how do you, a district court judge, have the authority to overturn decisions of the Supreme Court?" He says, "Oh, those were old decisions." I said, "Those are standing decisions. They have never been overturned. I don't care how they are. You have no right to overturn standing decisions of the U.S. Supreme Court in a district court." Section 3, public law and public law and policy. He said, "Name any decision of the Supreme Court after 1938, and I'll honor it. But all the decisions you read were prior to 1938. He went on, "Prior to 1938, the Supreme Court was dealing with public law. Since 1938, the Supreme Court has dealt with public policy. The charge that Mr. S was being tried for is a public policy statute, not public law. And those Supreme Court cases do not apply to public policy." I asked him what happened in 1938. He said that he already told me too much. He wasn't going to tell me anymore. Section 4. In 1938, Section 4, 1938, and the Erie Railroad. Where did I read this? I read this in another book or something. Okay. Well, I began to investigate. I found that 1938 was the year of the Erie Railroad versus Tompkins case of the Supreme Court. It was also the year that the claimed they blended law with equity. I read the Erie Railroad case. A man had sued the Erie Railroad for damages when he was struck by a board sticking out of a boxcar. as he walked along beside the tracks. The district court had decided on commercial law, negotiable instruments law. This man was not under any contract with the Erie Railroad, and therefore he lacked standing to sue the company. Under common law, natural law, he was damaged and he would have had the right to sue. This overturned a standing decision of over 100 years. Swift versus Tyson in 1840 was a similar case, and the decision of the Supreme Court then was that in a case of this type, the court would judge by the common law, natural law of the state where the incident occurred, in this case, Pennsylvania. In the Erie Railroad case, the Supreme Court now ruled that all federal cases will be judged under the negotiable instruments law. There will be no more decisions based on common law at the federal level. So here we find the blending of law with equity. This was a puzzle to me. As I put these new pieces together, I reasoned that all our courts since 1938 were merchant law courts and not common law courts. There were still pieces missing from the puzzle. A friend in court. Fortunately, I made a friend of a judge. Now, you won't make friends with a judge if you don't go into the court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. If you go into court as a wolf, if you make demands and tell the judge that what the law is, how he had better uphold the law, or else, remember the verse, I send you forth as sheep in the midst of wolves. Be ye therefore wise as serpents and harmless as doves. We have to go into court and be wise and harmless and not make demands. We must be humble and play a little dumb and ask a lot of questions. Well, I asked a lot of questions and boxed the judges into a corner where they have had they had to give me a victory or admit what they didn't want to admit. I won the case, and on the way out, I had to stop by the clerk's office to get some papers. One of the judges stopped me and said, "You're an interesting man, Mr. Freeman. If you're ever in town, stop by, and if I'm not sitting on a case, we will visit." Section 6, America is bankrupt. Later, when I went to visit the judge, I told him of my problem with the Supreme Court cases dealing with public policy rather than public law. He said in 1938, all the higher judges, the top attorneys, and the U.S. attorneys were called into a secret meeting, and this is what we were told. America is a bankrupt nation. It is owned completely by its creditors. The creditors own Congress. They own the executive. They own the judiciary. And they own all the state governments. Take silent judicial notice of this fact, but never reveal it openly. Your court is operating under admiralty jurisdiction. Call it anything you want, but do not call it admiralty. Section 7, Admiralty Courts. The reason they cannot call it admiralty jurisdiction is that your defense will be quite different in admiralty jurisdiction from your defense in common law. In admiralty, no court has jurisdiction unless there is a valid international contract in dispute. When you know it is admiralty jurisdiction, and they have admitted on the record that you are in an admiralty court, you can demand that the international maritime contract to which you are supposedly party and which you supposedly have breached be placed into evidence. No court has admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb. Well, I never knew that I got involved with the international maritime contract, so I deny that such a contract exists. If this court has taken jurisdiction in admiralty to place the contract into evidence so that I might challenge the validity of the contract, what they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation and that we are the bankers' slaves. Section 8, not expedient. But the bankers said it is not expedient at this time to admit that they own everything and could foreclose on everything on every nation of the world. This is the key behind the buildup of the United Nations as a military force. This is the key to disarming America. This is the key to ending the Cold War. Like now, we have no more enemy, so we can melt all our guns. Wrong. The bankers plan to foreclose. They just don't want their heads blown off while doing it. So they dictate to Congress to get rid of the guns, etc. The reason they don't want to tell everyone that they own everything is that there's still too many privately owned guns in America today. There are cooperative armies and other military forces. So until they can gradually consolidate all armies into a world army and all courts into a world court, it is not expedient to admit the jurisdiction of the courts they are operating at. When we understand these things, we realize that there are certain secrets they don't want to admit, and we can use this to our benefit. 9. Jurisdiction. Section 9. Jurisdiction. The Constitution of the United States mentions 3 areas of jurisdiction in which the courts may operate. Section 10. Common law. Common law, natural or constitutional law, is based on our Creator's laws as originally presented by Moses. Anytime someone is charged under the common law, there must be a damaged party. You are free under the common law to do everything you please, as long as you do not infringe on the life, liberty, and property of someone else. You have a right to make a fool of yourself provided you do not infringe on the life, liberty, and property of someone else. Common law does not allow for any government action which prevents a man from making a fool of himself. For instance, when you cross the state line, you will probably see a sign which says, "Buckle your seatbelts, this is the law." This cannot be common law because who would you injure if you do not buckle up? Nobody. This would be compelled performance. But common law cannot compel performance. Any violation of common law is a criminal act that is punishable. Section 11, equity law. Equity law is a law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So if you have compelled performance. There must be a contract somewhere, and you are being compelled to perform under the obligation of the contract. Now, this can only be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of the contract if you then refuse to perform as directed by the court. You can be charged with contempt of court. This is a criminal action. Are you set? Are our seatbelt laws equity laws? No, they are not, because you cannot be penalized or punished under equity jurisdiction for not keeping to the letter of a contract. This has, of course, changed since the publishing of this article, so read on. Section 12, Admiralty or Maritime Law. Admiralty is a civil jurisdiction of compelled performance which has criminal penalties for not adhering to the letter of a contract, but this only applies to international contracts. Now we can see that jurisdiction, the seatbelt laws, and all the traffic laws, building codes, ordinances, taxes, etc., are under. Whenever there is a penalty for perform, such as willful failure to foul, that is Admiralty Maritime Law, and there must be a valid international contract in force. However, the courts don't want to admit that they are operating under Admiralty Maritime jurisdiction, hereafter noted as AM. Woo! So they took the international law or law merchant and adopted it into our codes. This is what the SC decided in the Supreme Court decided in the Erie Railroad case, that the decisions will be based on commercial law or business law, and that there will be criminal penalties associated with it, since judges are instructed not to call it Admiralty, Admiralty Maritime Jurisdiction. They call it statutory jurisdiction. I looked for statutory jurisdiction in the fourth edition of Black's Law Dictionary. It's not there. So I looked up statute, and under its definition is this paragraph. This word is used to designate the written law in contradiction to the unwritten law. Foster versus Brown. 199 GA 444 34 SE 2D 530 535 C common law. Unwritten law is common law. Contradiction Contradiction means as opposed to, opposite to. Section 13. The courts of contract. You may ask how we got into this situation where we can be charged with failure to wear seatbelts and be fined for it. Isn't the judge sworn to hold up to uphold the Constitution? Yes, but you must understand that in Article 1, Section 10 of the Constitution gives us the limited right to contract as long as we do not infringe on the life, liberty, and property of someone else. Contracts are enforceable, and the Constitution gives two jurisdictions where contracts can be enforced: equity and admiralty. But we find them being enforced in statutory jurisdiction. This is an embarrassing part for the courts that we can use to box the judges into a corner in their own courts. We will cover this more later. Section 14. Contracts must be voluntary. Under common law, both parties must enter into every contract knowingly, voluntarily, and intentionally, or the contract is unenforceable and void. These are characteristics of a common law contract. There's another characteristic: the contract must be based on substance. Contradictions. For example, contracts used to read for $1 and other valuable consideration, I will paint your house, etc. That was a valid contract. The dollar was a genuine silver dollar. Now suppose you wrote a contract that said for one Federal Reserve note and other considerations, I will paint your house. And suppose, for example, I painted your house the wrong color. Could you go into a common law court and get justice? No, you could not. No substance, no contract. You see, a Federal Reserve note is a colorable dollar as it has no substance. And in a common law jurisdiction, that contract would be unenforceable. Colorable, that which is in appearance only and not what it purports to be. Hence, counterfeit, feigned, having the appearance of truth. Black's Law Dictionary, 5th edition. Section 15. Colorable money and colorable courts. The word colorable means something that appears to be genuine but is not. Maybe it looks like a dollar and maybe it spins like a dollar, but but it, if it is not redeemable for lawful money, silver or gold, it is colorable, fake, false. If a Federal Reserve note is used in a contract, then the contract becomes colorable, a colorable contract. And colorable contracts can only be enforced under a colorable jurisdiction. So by creating Federal Reserve notes, the government had to create a colorable jurisdiction to cover the kinds of contracts that use them. We now have what is called statutory jurisdiction, which is not a genuine admiralty jurisdiction. Judges are enforcing colorable admiralty jurisdiction because we are using colorable money. Colorable admiralty is now known as statutory jurisdiction. So let's see how we got under this statutory jurisdiction. Hold them up. I'm gonna be right. Well, ain't nobody right here right now. But if a motherfucker watch this later, I gotta go get these little nigglets off of them games so they can go to, so they can until they has to go to sleep so they can wake up and be ready for school tomorrow. I'll be right back. my fault. I'm gonna fuck this video up. What was this? Hit me on the. Nigga, I was texting you one day, nigga. You gonna tell me quit texting your phone? I won't let me do it.